The broadcast is now starting. All attendees are in listen-only mode.
Good afternoon, everybody. Welcome and thank you for joining us today for our webinar on in-home supportive services, parent provider issues, assessments and electronic visitation verification. So before I introduce our wonderful speaker, I'm going to tell you a little bit about Family Voices of California. So my name is Pip Marks. I am the Project Director for Family Voices of California. We're a statewide coalition of locally based parent-run centres working to ensure children and youth with special healthcare needs receive quality healthcare. And as the state affiliate of National Family Voices, we're California's federally funded family-to-family health information centre and provide statewide support and resources to families of children with special needs. These webinars that we host serve as statewide trainings on various child health topics and are geared towards very diverse audiences, families, professionals, parent-to-parent resource staff, and advocates. So a little bit about the platform that we're using today. If you have any technical difficulties at all, you can call the GoToWebinar directly on the number on the screen that you see. And due to feedback issues, we have everybody on mute from our end. Throughout the webinar, please feel free to type in any questions that you have in the question box on the right-hand side of your menu. We'll stop periodically to address your questions and also save some time at the end for any additional questions. Today's presentation is being recorded and will be archived on our Family Voices of California website along with the slides. And afterwards you're going to be emailed a very short evaluation survey, and we'd really appreciate you taking the time to give us your invaluable feedback. So it's now my pleasure to introduce today's speaker, Elizabeth Zirker. Elizabeth is the Managing Attorney of the Healthcare and Home Community-Based Services Practice Group with Disability Rights California. She focuses on working to increase and strengthen home and community-based services through individual advocacy, policy work, and participation in impact, litigation, and groundbreaking California Olmstead cases. Elizabeth's practice includes particular emphasis on the in-home supportive services, the IHSS program, and Medi-Cal home and community-based waivers. She received her law degree from the University of California, Berkeley School of Law, and was a 2005 Bouchard Fellow in Law and Aging with Disability Rights California, and has worked there ever since. It is now my pleasure to introduce Elizabeth, and I'm handing the presenter role over to you. Take it away.
Okay, thank you, Pip. All right, so do you see the slides now?
Yes, it looks great.
Okay, great. So I wanted to talk today about a number of things within the IHSS program, and I'm going to try to leave plenty of space for questions as I go through the various topics. So want to cover what is IHSS, who is eligible, the kinds of services IHSS covers, when parents can be paid as IHSS providers, and finally, electronic visit verification, which is part of the 21st Century Cures Act, federal law, and the impact on the IHSS program. So what is IHSS? It's a Medi-Cal program. It's a statewide program with approximately 550,000 recipients who get in-home supportive services provided by a paid provider if they need assistance doing things that they can't do themselves. Services include paramedical services, which I'll talk a little bit more about further on, protective supervision for people with cognitive disabilities, and other travel and other kinds of benefits. It's a statewide program administered by counties under the direction of the Department of Social Services, which is CDSS. IHSS is meant to be an alternative to out-of-home placement for people with disabilities. So California residents are eligible for IHSS if they excuse me, have disabilities or are 65 years of age or older. They're SSI, SSP, or Medi-Cal eligible. You do have to be Medi-Cal eligible to receive IHSS. You have to live in the community, so a home or an apartment, not a hospital, a nursing facility, assisted living, or licensed care facility. And you have to not be able to live safely at home without assistance. I will just mention here that one of the things that people encounter when they are applying for IHSS is not being assessed in the facility. So if they're in a hospital and they need to go home, or a nursing facility and they want to go home, they may encounter a county saying that they can't be assessed until they actually go home. I just want to flag for people that that is not that's not the case. There is an all-county letter that I can send to anyone who's interested about the requirement that assessments actually happen in facilities for someone returning home. And then usually when you get home, they reassess to make sure that the hours were properly apportioned. So children can receive IHSS as well. And IHSS does take into account the needs that a child with disabilities may have that a child without disabilities doesn't have. So children who have a disability and need IHSS can receive personal care services, related services, and both of those I'll talk a little bit more about further on. Paramedical services if prescribed by a doctor, protective supervision, and assistance with travel to approved places. So there's categories of services, and those are domestic, related, personal care, accompaniment, paramedical services, some time-limited services, such as like a deep cleaning, and protective supervision. Domestic services are housework, sweeping, vacuuming, taking out the trash, cleaning a wheelchair, recharging a battery, changing the bed sheets. Related services is the meal preparation and cleanup, doing laundry, going to the grocery store, and other shopping and errands, so picking up prescriptions, buying clothes, toiletries, that kind of thing. So personal care services include feeding, bathing, grooming, bowel and bladder care, dressing, transfer, so getting in and out of bed, in and out of a car, up and down out of a seat, oral hygiene, ambulation, help with prosthetics, so helping someone put on a brace, for instance, and help with medication. And all of these, the way that the county is going to determine these kinds of services are in the in-home assessment. So Disability Rights California has on its website a lot of information about IHSS, but these categories are allotted in time per task. So if you are preparing to apply, or if you want more services and time for various services, it's really important to be working on documentation of how long, feeding the recipient or your child or whoever you're providing care for might take. If that activity takes longer because someone may have swallowing issues, those are kinds of things that are, I'm not going to talk about at length today, but that is how those services get allotted. So then there's these time-limited services I mentioned. You have some heavy cleaning, yard hazards, shoveling ice or snow, which is not, plenty of places in California wouldn't necessarily come up. There's some teaching and demonstration services that people can receive, so helping, show how to do housework, meal prep, laundry, bathing and feeding and dressing and yard work. But there's a 3-month maximum. And so then there's accompaniment, which is transportation to and from medical appointments. And in some cases, you'll get, in addition to the travel time paid to go to the medical appointment, there's relatively new rules around providers receiving payment for waiting essentially when they can't do anything else because the appointment requires that they be there, or the time limit of the appointment is such that it wouldn't allow them to go do a personal errand. So that's sort of wait time on duty versus wait time off duty. There's also transportation to and from places where people get what's known as alternative services to IHSS, so day programs or resource centers. And you can get accompaniment for children. I mean, what comes up a fair amount when people call Disability Rights California, we hear about people being told by counties perhaps that all children need to go to the doctor, so parents can't be paid for taking their child to the doctor. But there are circumstances in which someone needs to take a child who doesn't have sort of average needs for going to the doctor. So you can get medical appointment for minors if you can show that the child has an assessed extraordinary need. An extraordinary need would be a need that is based on the functional impairment due to the minor's disability, where the need is beyond what would be normally expected for a child of the same age without that functional impairment. The appointment has to be with a physician or other healthcare professional in a specialty care discipline, and the appointment has to be related to the child's disability or functional impairment. So it's not to be authorized for routine pediatrician visits, primary care doctor like well child or annual checkups or immunization, or visits related to common childhood illnesses. And then finally, the child has to have a need for an authorized IHSS task during the travel to and from the appointment or at the appointment. So the other difference for this for children is that there's guidelines for authorizing the wait time on and off duty for adults, but they're not applied for minors because a parent is typically expected to be present during the child's appointment so they can participate in a discussion with the doctor about the child's health and make decisions about treatment. So that wait time should always be included if the child's accompaniment to an appointment has been authorized. And I've included a link to a specific publication around provider wait and travel times because I'm not going to talk about the work week limitations in this presentation, but part of there was changes to federal law around overtime, and the way it was implemented in California in the IHSS program included additional travel time payments for providers for appointments, for wait time, as I discussed, as well as some limited amount of payment for providers who go to multiple different recipients to travel in between those recipients. So paramedical services are services that are prescribed for a person's health and require some training and judgment to perform. IHSS services can include these services if they're ordered by a licensed healthcare professional who's allowed to order them under law, and which people could provide for themselves except for their functional limitations. So, examples of paramedical services. They can include administering medications or giving injections, range of motion exercises, pressure sore or wound care, catheter insertion, bowel programs, enemas, suppositories, people who need who get nutrition from tube feeding, as well as tracheostomy care and suctioning. One of the important things about paramedical services is assigned authorization, and the form is called the SOC 321. There are a number of different IHSS forms that are sort of important. This is one if you have a recipient who needs paramedical services. And when you can get them authorized, you need to be able to show that the person cannot perform the service at all. The activity is necessary to maintain their health, and the service requires training and judgment, such as puncturing skin, inserting a medical device. One of the things that makes that paramedical services are really important for families is that this allows people who can get trained by medical professionals to do things that would normally be done by a medical professional. It allows people to not have to take a child in to the doctor or try to get home nursing for something that they can themselves be trained to do. And so it's a special part of the origin of this is a waiver of the Nurse Practices Act, which is usually requires, medical procedures to be done by medical professionals. So one of the things that we see many times is making sure that when a doctor is given the SOC 321 to fill out, they understand what its purpose is, and they also understand just how long it will take the provider to do the activity. So preparation to clean up, including record keeping, such as diabetes, testing, administration of injections, if a child needs oxygen, including the time that you need to move the cannula, do all of the pieces and parts of ensuring that the service is completed. One of the things that we recommend is that you don't allow, you need to cooperate with the county, of course, but it's important to also speak to the doctor directly and explain what is needed, and don't let the county sort of say, oh, we'll call the doctor and ask. The other thing that we strongly recommend is if the child has a specialist who is, the pulmonologist, for instance, they be the person who fills out the paramedical form rather than the pediatrician who may not know the extent of the services that are being authorized by the pulmonologist. And this can mean really significant differences in hours authorized. So it's an important thing to really keep in mind. And maybe I'll stop there to see, Pip, if there's questions so far.
Yes, there is a question, Elizabeth. It's from Eileen. She's asking, she said, do they have to offer translation for monolingual speakers for the in-home visit? We've had families not get a lot of ours because they did not understand the questions.
Yes, they absolutely should have a translator if the family doesn't speak English, they should have someone who speaks the family's language so that they can understand the assessment process. And I would certainly, there's a procedure for filing for a fair hearing, which we've had people dispute hours assessed because they didn't have a translator at the assessment, so they didn't understand what they were being asked. It's absolutely required that they get a translator.
Okay, thank you. That's all the questions.
Okay. So the next slide is protective supervision. So I'll say that the language on this slide is from the regulations. IHSS regulations and rules are found in a variety of places. This is sort of an aside, but there is what's called the Manual of Policies and Procedures, and that is one of those are the CDSS regulations that govern IHSS. There's also all county letters that go out to the counties that are advocates and recipients frequently use to advocate for themselves. But just to say that this is protective supervision is for people who have a mental illness or mental impairment and are non-self-directing and require 24-hour supervision to safeguard against injury, hazard, or accident. So the impairment that somebody has if they need protective supervision, the impairment causes functional limitations in their memory. They forget things, people, places, how to get home, orientation, awareness of time, self, other people, wandering, not being able to identify family or friends, not having a sense of time of day, and judgment, making decisions without regard to safety, and not being able to recognize and assess danger. So this is a list of there's a kind of standard list of things that warrant a need for protective supervision. People who wander from home, don't have safety awareness, get lost. People who eat non-food items, walking into the street without checking for cars, trying to do things beyond physical or cognitive capacity without an understanding of the risk of injury. So people who might try to move furniture or heavy objects, climbing onto a counter. I have worked with families where you have a person, a senior, who gets up without using their mobility device, without their walker, and falls because they don't remember or don't understand that they need their walker in order to stand up. Turning on the stove and not turning it off. Self-injurious behavior that is not self-directed, so not purposeful, and then lack of stranger danger awareness. These are all relatively common things that we see. Oops. So when can you not get protective supervision? You can't get it for friendly visiting or social activities. You can't get it when the need is caused by a medical condition and the form of the supervision required is medical. So someone who has diabetes and needs supervision in case they become hypoglycemic, that person would probably, you'd want to get paramedical services for administering insulin and checking levels. That would be okay, but it wouldn't be something that you could get protective supervision for. In anticipation of a medical emergency. So someone has heart failure and you need to be with them in case they have a heart attack. Preventing or controlling antisocial or aggressive behavior, getting into fights or destroying things, and guarding against deliberate self-destructive behavior. So somebody purposely is trying to harm themselves. Now, one of the things that this comes up frequently in the cases that we see, that someone has a need, someone has diabetes and doesn't understand that they have to watch the kinds of things that they ingest. We have successfully argued in our cases that while the intervention to stop them from becoming hypoglycemic because of the things that they are eating that they shouldn't eat, that intervention itself is not necessarily, you can't get protective supervision for it. We have argued that inability to understand that medical condition goes to their lack of judgment. So it's, I think that this is in every case that we see with protective supervision where somebody has been denied or the county wants to terminate it, it really requires a careful kind of look at each individual situation, because it can be complicated, but you can also use things like that lack of judgment to go towards the eligibility, even if you need to use paramedical hours to intervene to on a diabetic emergency. And the same with antisocial or aggressive or deliberate self-destructive behavior. There is an ACL, which ACL, All County Letter 1525, which expanded on the standard for protective supervision. It's a pretty important ACL to have if you're trying to argue for someone to get or keep protective supervision. But you can still get protective supervision even if you have excluded behaviors. So let's say you have purposeful destruction of property, but you also have other behaviors that meet the standard for protective supervision. Because it's a 24-hour need, you still can argue that the person is eligible for protective supervision, even if you agree that it can't be for preventing antisocial or aggressive behavior.
Elizabeth, this is
yes.
Now there's a couple of questions coming in around this protective supervision, and one is, protective supervision is a major issue for families with a child with autism who acts in ways that endanger themselves. What do you recommend for parents to be able to provide documentation of that?
Well, that's a good question. I think I will go to my next slide in part to answer it. Do you want to ask the other one or just stick with that one?
There are a couple others. Somebody is asking if you could expand on when you're talking about seizures. And the other one was, for children, what is your take on sharing a child's IEP when looking for protective supervision?
Okay. Let me just write this down. So if the question is, the child has multiple seizures and you need to be watching them, I would say that's a pretty kind of classic thing that you cannot get protective supervision for. There's a federal court case called Nora Singh v. Lightbourne, which was a case in which a recipient had neurogenic seizures. So that question is perhaps a more complicated question I could address offline, but I would say it's going to be very fact specific. If you could show, and Nora Singh would be an interesting case to look at if that child or person fell into that category. For sharing, was the question IPP or IEP?
No, IEP.
IEP. I think that I think this is a sort of a hot issue, I know, because people feel sometimes that they don't want to have to share everything and that counties are overreaching. I think that it is generally important to cooperate, because saying that you're not going to give a document to the county often, in our experience, has ended up in a denial or termination for failure to cooperate. So it gets more complicated. What I would say is you certainly want to share something that is helpful and supports the need for protective supervision. If it's not helpful, I think that one of the things you want to consider is how can you explain why it's not relevant to protective supervision. So for instance, if the goals in the IEP are aspirational, and those plans are supposed to be person-centered, and you're trying to have the person reach their potential and their goals for whatever they have in their life, then you can explain that you can explain the context for that document. And I think that we've had some success with doing that. The other thing would be to ask the regional center if they'll provide additional letters or supportive information about the person's need for protective supervision, notwithstanding whatever is in the IEP that you are not sure will be helpful. So in terms of the issue about autism and children with autism and their need for protective supervision, that's a fair amount of the cases that we see with children have often, multiple diagnoses, but including autism. The big picture issue is the child must need supervision due to their disability and not routine child care. They must need closer supervision than other children of the same age. This comes up often with callers who maybe have a 2-year-old or a 3-year-old with autism, and they get denied based on the age. It can be hard. You can make an argument that a child of that age wouldn't, because of the disability, that child needs more care. But it's a little harder the younger that the child is, but we have seen families be successful. So I think that one of the things that you want to do if you're trying to get protective supervision for any child are knowing what the forms are. So the assessment of the need for protective supervision, which is the SOC 821, it's completed by a doctor. Like the paramedical form, it could also be completed by a psychiatrist or a psychologist. If your pediatrician isn't able to, adequately fill the form out because they're not aware of the child's behavior, you can sort of target who you'd like to have fill out that form. It doesn't alone establish eligibility. One of the next things you have to submit is a 24-hour-a-day coverage plan. Preparing that is another way to demonstrate the round-the-clock need for the child. Creating a hazard or injury log. So how many accidents or almost accidents have happened, how often it has happened. There can be distant past accidents. It makes the case a little harder, but it's not an absolute bar, and it's also not a bar that no accident has happened. The potential for accident and injury because of the impaired judgment of the child or person can get them protective supervision. We have had people, this is a very rare instance, but we do have a publication that gives examples for the hazard and injury log, and we have had one ALJ compare somebody's hazard log to our publication, and they were very identical. So I would say, I think at this point, a lot of our advice to people is pretty well understood and known by administrative law judges, who would be the people hearing a dispute about, whether or not you've been granted protective supervision. So you want to really try to keep track of these kinds of things. It can be really helpful. So getting letters to document the need, getting the school, a regional center, day program, doctor, multiple doctors that describe how these limitations in the memory, orientation, and judgment warrant a need for the 24-hour supervision. It gives examples of unsafe behaviors and their frequency. I would really recommend that as much as possible, when you get any doctor's letter or any letter to document the need, you make sure that the doctor understands what protective supervision is and isn't. This is one of the things that can be, it's not insurmountable, but if you don't have a clear kind of connection of the standard for protective supervision with what a doctor or somebody else is saying about the child, it's a lot harder to get the benefit. So, if they focus particularly on suicidal behavior of a recipient, unless that behavior is not self-directed, it's gonna be an excluded kind of behavior for protective supervision. So then again, with the SOC 821, you have to, of course, be accurate, have the doctor accurate. But we see if the county gets an SOC 821 where there's no deficit, no disorientation, no impaired judgment, that person is very unlikely to get protective supervision. And again, you don't have to have all of the severe checked. I think that there's some kind of internal sense in the counties that unless they're all three severe, they don't want to give you protective supervision. That's not the standard, but really explanations on that form or an attachment from a doctor are very important. Often we see the form, a couple of things have been checked. There's not clear, legible writing about what the examples are. You also need to have them address whether or not the person has the physical capacity to place themselves in danger. That's a very important factor in protective supervision. So just really having a handle on filling out the form and how to talk to one's treating professional who's filling out the form is a step towards getting protective supervision. And so before I go on to parent providers, Pip, do I have any more questions about protective supervision?
We have a question about IHSS tube feeding. This person, Peggy says, I completed a paramedical form based on a family's description of time to do tube feeding, but the worker said that was not how time was counted and redid the form with different amounts of time per task. Do you have any suggestions regarding something like this?
I would absolutely ask for an explanation of why the worker is more. I mean, if Peggy is a medical professional, I think that they are not. It's really worth considering appealing that. I think we see county workers doing that all the time, which is why we really emphasize making sure that the person who understands what the child needs is the one who fills out that form. So I would recommend filing for a fair hearing. If you filed for a fair hearing, sometimes what you get is the county says, okay, we'll agree to reassess or we'll agree to go back to the doctor and get additional information, and they offer a conditional withdrawal, which is a way to sort of, if they fulfill the things that they're offering to do, then you would agree to withdraw the hearing with the right to refile. But I think that's an example of something I would challenge.
Yeah, thank you for that answer. So that's all the questions. So you can now move on to your.
Okay, great. So this is another thorny, complicated issue that each time we get a question about a parent provider at DRC, we have to go back to the regulations about when parents can be providers, because there is a logic to the rules, but it can get quite circular. So it's really important to understand all of every individual situation. So parents can be IHSS providers, and here I'm talking about parents of children who are under 18. So if you have a child who's an adult you're still caring for, these parent provider rules are no longer, these restrictions for parent providers are no longer applicable to you. So parents can be paid as IHSS providers if they've left full-time employment or they're prevented from obtaining full-time employment because there's no other suitable provider, and the parent not being the provider may result in inappropriate placement, out-of-home placement for a child, or inadequate care. So the other thing that we have seen that seems to have been subsiding, but if it comes up, it's not appropriate, is demanding to see that a parent has a work history. So that they have to show that they used to have a job and they had to leave. That's not the standard. If someone has a child who's born with significant disabilities and has always been caring for them in the home and isn't able to show that, that's not something that they should be penalized for. So, and this is a slide sort of directly addressing that one of the parents works outside of the home and one works at home to take care of the children, and that at-home parent can be the provider as long as the conditions are met. So there are a number of different examples that CDSS has provided in various different all-county letters. But again, it's important to really look at the regs and look at each individual situation, how many, two parents, who is working, neither is working. You really need to figure that out. If neither parent is able to be the provider, you can have a non-parent provider to a minor. So in those situations, you can have a non-parent provider if neither of the parents is able or available to provide services to the child because of their employment, their education, or training, because of their own physical or psychiatric disability, ongoing medical or dental or other health-related treatment, or because the parent needs to perform shopping and errands essential to the family, search for employment. Oh, I'm sorry, just skipped slide. Or for essential purposes related to the care of the minor's children. Now, the last bit so you can have a non-parent provider because the parent is unavailable to perform shopping and errands essential to the family, this last clause, this is allows up to 8 hours per week for if it's, I'm sorry, this last clause, because you need to perform shopping and errands, essential purposes related to the care of the other siblings, that's only allows a non-parent for up to 8 hours per week. But if the parent is working full-time, and both parents are working full-time, then you could have a non-parent provider. And I'll just note that full-time employment is defined as 40 hours or more. in the IHSS regulations. Pip, do I have any questions?
Yeah, there's been an interesting comment. Eileen commenting on what you just she said, we also this is at a family resource center. She said we also tell families to not have adult family members around the home when the home visit occurs, because they're then told that they have community support and that they don't need IHSS. Yeah. And then, okay, at the end, there's other questions, but not relating to what you've just been talking about. So I'll hold those off till the end.
Okay. I would say, you know, we've also heard about people being asked to sign. There's a form that says I voluntarily agree to provide IHSS even though I know I can get paid. You don't have to sign that form. It's a voluntary form. They can't force other adults in the family kind of circle to be IHSS providers. I understand that as a practice tip, you might want to avoid that being sort of gone to by a social worker, but they're not allowed to do that.
Okay. One more, Elizabeth. Yeah. It's from a mom. Sorry, I just got to go back and find it again. Sorry. This mom says, at our recent annual review, the caseworker observed outside caregiver was taking care of the IHSS recipient while mum was working and asked about it. Mum works part-time but not full-time because of needs of the disabled child. The caseworker said external caregiver needed to sign up as an additional IHSS provider or fill out the voluntary services certification. Do you have any thoughts on that?
I guess I would be curious about what if the other person about the number of hours that are entailed. I actually think that would be the kind of question you might want to send to me, Pip, and then I could try to respond and see if we need to do follow-up, because I think that sounds okay, but I would want to know a little bit more about what's happening. I mean, I think the idea of, it depends too if the child has a protective supervision need, so it might be simply part of the 24-hour care plan. I've seen 24-hour care plans for someone who needs protective supervision where there was a wife who's the provider, and then there were some neighbors who would sometimes watch the husband as part of the, how do we account for the 720 hours of the month that actually exist, you know.
Right.
You've got a much smaller number of IHSS hours that are paid.
Okay, there's follow-up comments from Anne about that. I'll send this to you in an email after the. So, and I know that you've got lots more to go through, so I think that we'll hold off these other questions till later.
Okay. Okay.
Thank you.
Sure. So, multiple children. Can both parents be the provider, and how are hours divided? Yes. So if both parents can show that neither of them is able to work, or they're both prevented from working and there's no other suitable provider to prevent inadequate care or out-of-home placement for the children, you can have two parents be providers for multiple children. When there are multiple children or multiple people in the household who all need IHSS, some of those IHSS services may be prorated to account for shared needs. And you can actually also have prorated protective supervision. It can get extremely complicated. We do have a publication that goes through how to calculate proration for multiple children with protective supervision. But again, it's a very fact-based situation. I will say, and I haven't really talked about this either, but it's also complicated by insertion of what are known as alternative resources. So I think if people have questions about multiple children, that might be a sort of more extended discussion, but I'm happy to try to address those offline. We have successfully had gotten, protective supervision for families with 2, 3, and 4 children with autism, where both parents have to be the providers. But again, then you end up with some complicated situations around the work week limitations too. So, Pip, do you want me to stop here before I go to electronic visit and go through some of the questions now?
No, there's a couple that I need to, they're quite personal, so I'll send them to you with an email so you can answer them personally. There is just one other question. It's not, you haven't covered this, but it's about the annual reassessment. Peggy's asking, often families are waiting to increase hours, but the work doesn't come back for several years at a time.
I think if you have an overdue assessment or you need hours, you make a request for the hours, and if they don't respond, you file for a fair hearing. And they, we know that they don't do their annual reassessments on time, but at any point, a family who says my child needs more hours, they have the right to ask for them, and if they get a no or no response, file for a fair hearing.
Okay, good to know.
So this last few slides are about something called Electronic Visit Verification. It was part of this federal legislation, which was signed into law in 2016, and it requires that all states implement this verification for Medicaid-funded personal care services, as well as home health and other personal care services. There has been a lot of concern about EVV and its overreaching into people's privacy, and I think, and it has not yet been implemented in California. The federal law is pretty vague about what it really means to verify that a service was completed. California is doing a sort of phased implementation with stakeholder participation, and it's focusing first on IHSS and WPCS, which are the waiver personal care services people can get if they receive services under the home and community-based alternatives waiver, which used to be called the nursing facility acute hospital waiver. California's planning to implement this phase 1 of IHSS and WPCS next few years, and delay until January 2020. Then the phase 2 will focus on non-IHSS, so agency home health services, other kinds of personal care services. I've included a link to CDSS's info regarding IHSS and EVV. I will say that, DRC has been part of meetings around this and really has been pushing that whatever is implemented, it is done in the most low impact, least invasive, doesn't impact services manner. The department has, these are not DRC's principles, this is the CDSS principles around EVV. Collaborative stakeholder process, respecting recipients, doesn't alter Olmstead, minimally burdensome, doesn't change number of hours, won't be geo-tracking where people are, tries to use the existing timesheet system and provides training. I think that the department imagines that this may be something that allows people to get paid more quickly, and maybe actually possibly a cost savings, time savings, efficiency creating possibility. Obviously, the devil is in the details, but so far, this is kind of where things are. And there's information about, a lot more information on the EVV website that gives people more, if they're interested in more information, you can get more information about what's happening. So I think the rest is, we don't have very much more time, but any questions, I'm happy to answer.
Thank you so much, Elizabeth. There's one person, Martha, is saying that a parent who is the provider of an adult can work separately in a part-time job. I don't know if that's a question or if that's a statement. Is this correct?
Yes.
Okay.
Those rules don't apply to adults anymore.
Okay. And the other ones, I think I'm going to be emailing them to you.
Okay.
So that is it. So thank you again, and thanks everybody for joining us. That was excellent, Elizabeth. So it will be, as I said, it will be archived and posted on our website probably by the end of the day tomorrow. And I really do appreciate you filling out the evaluation. It's a very short survey that you'll get after the webinar. So Elizabeth, thank you very much for your time and your wisdom. Bye-bye.
Okay, bye-bye.
Bye.